And welcome again to Spain Residency. We have received an inquiry from a client who is basically asking whether the consulate can legally refuse an application for non-lucrative residency. Okay, the answer is yes, subject to a number of conditions. In principle, a consulate or any other immigration authority has to take on a file, because the law says that when you wish to make an application and you wish to achieve a result through the Spanish administrative system, so long as you comply with the documentation, then your file will be taken on and it will be read and it will be decided upon by the competent authority. However, there are situations where some consulate members have refused to take on applications, and not always they are right. These consulate members or staff many times are native to the country where the consulate is, and they don't have the knowledge of the law. For which reasons, I'd like to explain briefly in which cases is the consulate allowed to not take on, to reject a bundle of documents with your application. These are the reasons why your application can be refused without even being studied. Firstly, if the applicant has lack of personal entitlement to the case, or lack of authority by the representative. Obviously, if you act on behalf of a third party with whom you have no authority or you have no relationship whatsoever, the consulate will evidently reject that application. Secondly, filing of an application after the expiry date. This makes sense if the expiry date is notably past, then the consulate or the immigration authority will reject that application without going into the actual subject matter of the application. Thirdly, an application that was previously rejected, provided the circumstances have not varied. Fourthly, when the applicant has an administrative procedure ongoing for the expulsion of the Spanish territory. It makes sense that being in the process of being expelled, or in that situation, which is severe, which is grave, and applying to stay in Spain seems to be inconsistent. Fifth, when the applicant is banned from entering Spain. I don't think that needs any explanation, it's obvious. Six, when the applicant or the application is manifestly without grounds. In other words, for example, someone who is notoriously not a person that can be a resident of Spain. For example, a member of the diplomatic service of a country, say for example a gentleman from Pakistan who is posted in Japan and he wishes to relocate to Spain. Well, the consulate obviously, as soon as he sees that, then they'll say, well, sir, you are not obviously able to be in Spain because you work in a different country, and naturally that's not congruous, so therefore it will be not taken on. And lastly, when the applicant is illegally in Spain, this refers to applicants who are, for instance, applying through Spain for a golden visa, which is typical. A lot of people who have bought a house in Spain and wish to apply for golden visa from Spain, and their visa has expired, then they're not able to apply. Therefore, their case normally gets rejected at the beginning. I have to say, however, that although there are a number of reasons why your application can be rejected, very few people actually fall into one of these categories, which means that 95% of applications should be taken on by the consulate member of staff, and therefore be looked into and therefore be resolved on the basis of the merits of the case. Thank you.